Hello, and welcome to another episode of the Deep Dive Law. I'm your host, Matthew R. Carpenter, an attorney, and today I'm going to be talking to you about the beef between Nevada and Delaware. And you may have guessed it, the beef centers around shmoney, Skrilla, that bag, and how each state is trying to get it. Specifically by amending their corporate code, Nevada is trying to convince companies to consider its state instead of Delaware for incorporations. So let's unpack this. Nevada just passed this thing, Assembly Bill number 239, AB 239, and it sounds like it brings some really significant changes to the state. Our goal today really is to understand what's actually in AB 239, what it means for companies, and how it positions Nevada against the well and long-time heavyweight Delaware. They're going to squabble. They're going to squabble over this one. Yeah, so we're working from a few articles that analyze these changes. It seems AB 239 was proposed by Nevada's own state bar. And you kind of get to see the context here, right? Like Nevada, much like we've seen with Texas recently, is actively trying to, not to hide the ball, chip away at Delaware's dominance. And this bill, this AB 239, it's a direct response to that. They even reference developments in other states, Nevada that is, especially Delaware law and its recent changes. They're openly competing. They're watching Delaware closely, seeing what works, what doesn't, maybe where the controversies are, and trying to offer a compelling alternative. And one of the biggest areas AB 239 tackles is something Delaware itself has been, let's say, grappling with when it comes to fiduciary duties of controlling stockholders, right? So this is an issue in Delaware law. How do we handle fiduciary duties of controlling stockholders? So Nevada's weighing in on that, actually codifying these duties in a new section 78.240. So let's back up for a second. Who counts as a controlling stockholder in Nevada under this new rule? Is it like Delaware? Well, that's a key point. It's a good question, right? It's actually narrower than how Delaware often approaches it, especially under their section 144. In Nevada, for this specific section I just referenced, 78.240, you're only controlling if you have the voting power to elect a majority of the board of directors. A majority, okay? So it's tied directly to board control. Not necessarily just like a percentage of shares that might be seen as influential, right? So it gives a brighter line for what is required to become a controlling shareholder. It seems designed to avoid these sometimes ambiguous ownership threshold questions that can pop up in Delaware cases. Sneaky Nevada. Nevada's going for a clearer, maybe brighter line. Okay, so that's a really crucial distinction, right? So what's the actual duty then of a controlling shareholder? I think that's the next logical question. Well, the duty is defined pretty specifically in Nevada. It's about refraining from undue influence. So to make this more clear, when is there actually a breach duty, right, of a controlling shareholder? First, the actions of the controlling shareholder must cause a director to breach their duty. Second, the breach actually leads to liability for the director. And then third, it provides a material, non-speculative financial benefit to the controller that the other stockholders don't get. Proportionality. Good old-fashioned proportionality. Love it. And fourth, can't forget this point, it's a four-part test. It causes a material, non-speculative detriment to other stockholders, right? So it's quite a specific multi-part test, especially the bit about material financial benefit and detriment. It differs from how the Delaware standard has traditionally been articulated, which hasn't always explicitly required, say, materiality or purely a financial harm. Recent Delaware cases like Maffei are looking more at concrete harm. But interestingly enough, recent Delaware cases like Maffei are looking more at concrete harm. So Nevada's putting that right into the statute, trying to beat Delaware to the punch. Early bird catches the worm. So let's just focus for a second. Is there a way out of these implications if you're incorporating in Nevada, you're being investigated or sued, right? And yes, there is. They've included a safe harbor in section 78.245, and it looks a lot like Delaware's section 144. In some ways, approval by a committee of disinterested directors or the full board, if disinterested, can create a presumption that the duty by the controlling shareholder wasn't breached. Similar to Delaware then, but here's the difference. Nevada's safe harbor doesn't include the option for cleansing by a stockholder vote rule, which Delaware does allow under 144. So Nevada has mirrored parts, but not all of what Delaware has going on, selectively adopting, so to speak, as it continues on this course. Okay, so what else stands out in AB 239? Well, another big one is about litigation procedure. Section 78.046 explicitly allows corporations to put a waiver of jury trials for internal actions written into their articles of incorporation. That's huge. And it sounds like a direct nod to Delaware's court of chancery, where there are no juries, right? So giving the corporations the options. It's pretty awesome. And Nevada is basically offering companies that same kind of procedural predictability, judge-only trials for internal corporate disputes. Makes a lot of sense. What you doing, Nevada? I like what you're doing. All right, so are there any other alignments between Nevada and Delaware? Let's see. Well, a couple of other things seem to track recent Delaware responses to litigation outcomes. For instance, in AB 239, it clarifies that materials sent with a notice are considered part of the notice itself. Section 75.150. Okay, check it out. That reflects changes Delaware made to its own law. DGCL Section 232 after the whole Activision Blizzard case, love Activision, which in part was about notice requirement, right? And similarly, allowing boards to approve documents in either final or preliminary form, Section 78.315. That probably tracks changes to Delaware's DGCL Section 147, also influenced by Activision. All this really shows that Nevada is paying attention to Delaware, watching them as they sleep. And honestly, it's pretty wise. And Nevada is learning from Delaware's experience and maybe trying to preempt similar issues. Seems that way, at least. So putting all this together, Nevada seems to be making very targeted strategic moves. They're looking at Delaware law, Delaware litigation, and essentially saying we can offer that predictability, maybe with some slightly different, potentially clearer rules in a few areas that have been pretty ambiguous and fuzzy in the past. To me, that's exactly the picture that emerges. Nevada wants to be a serious contender. And this competition gets even more interesting when you think about the fact that Delaware's own corporate law is facing some serious turbulence right now. Well, so since I brought it up, let me talk about what's happening there just briefly. There's a case involving Dropbox, I believe, that's challenging the constitutionality of some recent amendments to the Delaware General Corporation Law. So you might be wondering on what grounds, right? Well, the argument basically is that these legislative changes might improperly curtail the traditional equitable power of the Court of Chancery. It's a pretty fundamental question about the balance between the legislature and the judiciary in Delaware corporate law. Yeah, and apparently Chancellor McCormick herself has even suggested the Delaware Supreme Court might need to weigh in on it. So there's some uncertainty brewing in Delaware itself. Okay, so wrapping all this up then, Nevada's AB 239 looks like a really significant calculated move. They're offering clarity, specific provisions, often adapting Delaware law, all clearly aimed at attracting more corporate incorporations. Definitely, Nevada, alongside Texas, is actively stepping up the competition with Delaware. The status quo is being challenged, which leads to a really interesting question for you, our listener, to think about. Given that Delaware's own recent legal changes are facing these constitutional questions in its own highly respected courts, what might all this instability, both the competition and the internal Delaware questions, mean for the future? Where will companies choose to incorporate, and how might the whole landscape of the U.S. corporate law shift? All right, that wraps up this episode of the Deep Dive Law. Thank you for listening.